Tom Clegg is concerned with at the
is Mayor
moment is
Bloomberg.
Mayor Bloomberg.
All right, here's another one from Elizabeth Etoll. Jeff, you guys...
Yeah, they would love nothing more than
Donna Formato on November the 19th of 2010 concerning information as to Andrea Sneiderman having been told her husband had been shot at Dunwoody Prep. There is a record in the file which we were provided by the District Attorney's Office of an interview that Mark Potter had conducted with Ms. Formato back in May of 2011, at which point she said that she was present when Sergeant Cordellino told Andrea Sneiderman that her husband had been shot. Okay. We also have reason to believe, based on my interview of Ms. Stansberry, that she was present when Ms. Formato, on the day after the shooting, basically related information concerning that Andrea Sneiderman was made aware of the fact that her husband had been shot and her physical reaction as such. Okay. She is now on the witness stand. You have seen Ms. Formato. She basically said she did not recall ever making those statements. Mr. Morgan attempted to direct her attention to those particular times, basically specifically asked her about those particular times, the 19th of November of 2010 and I believe May 31st of 2011, and sought to ask her specifically whether or not she had made those statements. There was an objection from the state as to those being leading questions. As such, by the court's ruling, he was not allowed to go into the fact that or even elicit from her an answer as to whether or not she had ever made those particular statements or had any recollection of them. Now, we will concede, typically a witness has to be confronted with a previous statement before another inconsistent statement can be allowed into evidence. But in this case, the state's objection and the court's ruling effectively prevented Mr. Morgan from doing so. He specifically sought and tried to do so as to each of these particular conversations. As such, we now are attempting to get into the statements that Ms. Formato made, at least at this point, to Elizabeth Stansberry, and the court is saying we haven't laid a proper foundation. But when Mr. Morgan, in fact, sought to lay that foundation, this court sustained the objection that it was a leading question. So we have effectively been precluded from laying the proper foundation, and now, having been precluded from doing that, even though we in fact sought to do that, are being prevented from cross-examining or producing evidence from this witness, which is inconsistent with what Ms. Formato said on the witness stand. Mr. Petrie also...
Let me ask you something, Ms. Clay.
Certainly.
You're making reference in this presentation about the Potter report and something that may be, I'm sorry, it was provided to you.
Yes.
And correct me if I'm wrong, at what point was Donna, presented by Mr. Morgan with that report to either refresh your recollection or to view? I understand the objection on, and I did sustain that, but at what point was she approached, or was that report given to her to refresh her recollection on whether or not she even had that conversation with Investigator Potter?
She was on the witness stand. Mr. Morgan did not specifically approach her with the document, but directed her attention to that specific day and sought to direct her attention to that specific discussion. I don't know of any rule that requires the party seeking to impeach a statement to use a piece of paper as opposed to directing the attention of the witness in open court. I do not believe there is any distinction or difference in that regard.
I'm not disagreeing with you on that report. The point was, as far as we may disagree on the summation of what you're giving, but I want to let you finish. Go ahead. Okay.
Mr. Petrie also looked up a case from United States versus, and I have no idea how to pronounce this, B-I-L-L-U-E at 994 F. 2nd from the 11th Circuit, 1993, and it is a summary from a treatise, I believe, that it basically says if a witness says he does not remember a statement, the statement may be proven by another witness. Okay. So I certainly think we can do that. I mean, the bottom line is we have attempted to go ahead and elicit from Ms. Formato the fact that direct her attention to these specific statements. We have sought to lay the foundation. The objection of the DA and the court's ruling have prevented us from laying the foundation. Now you're telling us we can't get in this statement through this witness as to what Ms. Formato said because we haven't laid a proper foundation. Well, how can we do that if the court won't allow us the opportunity to in fact do so?
Yes, Mr. Clegg, I understand what you just said, and I will definitely pull that case that you are citing now, and I'll have my staff there to pull it.
Sure.
And I have no problem taking a look at that particular case. Okay.
It's 994 F second. What is the page number, Joe?
Second, 1562, Your Honor.
All right, thank you. Ms. Jeffrey, would you pull that while I'm listening to the state's response?
And, Your Honor, Mr. Clegg has one more thing he wants to tell the court, I believe.
Oh, that's fine.
You don't have to confront you don't have to make an attempt to refresh the witness's memory in order to direct their attention specifically to what they have previously said. You are asking whether an attempt was made to refresh her memory. There was not, but that is not a condition precedent to an attempt to directing the witness's attention to a previous inconsistent statement, asking whether or not that previous inconsistent statement was made, and if they claim to forget, allowing us to prove it by other means.
I agree with what you're saying right now. Yes, I agree with that.
Okay.
We had the state's response. Who's Mr. James?
Yes, sir.
It seems to me to be pretty clear, Your Honor. Mr. Morgan was up here. He had Ms. Formato on direct examination, and he was attempting, and I'll stress attempting, to lay a foundation for a prior inconsistent statement. The problem is that Mr. Morgan didn't do it properly. I don't disagree with counsel, either counsel, in their assessment of the case law about someone stating that they do not recall. However, the problem is that the reason they were limited in terms of showing her that statement or bringing out what the potential statement they wanted to confront her with is because they weren't doing so properly. Our objection was leading because he was leading the witness and it was his witness. So the way not to lead her and to confront her with the statement is to give her the statement and ask her if it refreshes her recollection. That is within the four corners of the rules of evidence. Even when one is attempting to lay a foundation for impeachment or bring someone's attention to a particular statement, they still have to comply with the rules of evidence. And so the problem here is that the plane never got off the ground. Mr. Morgan never got past the first step, which was laying a proper foundation. It's not that his assessment of the law on the back end isn't correct. He has the ability, I know she's been released, but if they can find her and re-subpoena her, he can call her, put her back on the stand, and lay the proper foundation, but he's not done so.
Ms. Clegg, anything else for the record?
No, sir. Nothing further.
All right, Lori. What I'm going to do, Ms. Jeffries is pulling that most recent case that was cited, and I have no problem in taking a look at that. But I can tell you, I concur with Mr. DA's assessment on what took place, at least what I heard. But let me take a look at this case.
Jeff Hutlinger back with Jay Strongwater. Jay, what's going on right now?
I've missed the question that's caused the judge to take a break in the testimony. My understanding is that there was a question raised and the state has an objection, and rather than just a speaking objection of saying this is why we think it should not come in, they're supporting their objection with some type of case citation, which is pretty unusual for a mid-trial question and answer. Most of these questions would have already been anticipated by the state, and I say that at the same time they seem to have anticipated it because they have a case ready to throw up to the judge.
Are there more issues between the prosecution and the defense now that maybe we have not seen over the last few days, where there are more small points of contention between the two sides?
It's really a question of style.
Uh-huh.
I was asked by a judge once why you object so much, and I said my job is to make it as difficult as possible for you to make a clean record. And the judge would look at the prosecutor and say, your job is to protect me as well as try your case, because no one wants to try this twice. So if a defense raises a question, you need to come up with a good answer for me and avoid having me make hard choices.
Judge Adams has been interesting to watch through this. The courtroom is his biome, clearly. He
Yes.
is in charge of all things, has a good, keen sense of humor, and keeps things moving right on time, stands up seemingly when he needs to. A judge really is sort of like a point guard in basketball. He really kind of sets the tempo for the style and the speed of the game.
Exactly. And you had asked other attorneys that have shared their opinions with you, by being on time gets everybody on time. There's no delay. People are getting used to him saying 5-minute break and taking a 10-minute break. People straggle in a little later. The jurors start to not to trust the break time, and everything seems to slow down because people are taking liberties. The nice thing about elected judges is that they have to get out in the public.
Should judges be elected? It seems like the last thing that voters should decide when we can't even figure out our own renewal for our license plates and our driver's licenses.
In the days of nonpartisanship, it was a good, healthy idea. Today, that with elections where one side will find one case in 100 that irritates a particular voting bloc, then it becomes skewed.
It seems like the election of district attorneys also is an antiquated idea. Agree or disagree with my premise?
I like the elected executives. I like a nonpartisan, merit-based judiciary.
Now, also explain, and this is a question that we have had oft repeated over the last couple of weeks, and that is why Judge Adams is presiding over this case as he did with Hemi Newman.
Well, he was randomly assigned the Hemi Newman case. Having sat through all the pretrial motions and made rulings, having heard both testimony in court plus things that are said in chambers, it would be inefficient to suddenly assign it to another judge who would start the whole process again.
All right, let's go back into the courtroom. Well, before we sign it off, I think we better hang on here, Jay Strongwater,
Okay.
as the attorneys step up. It's interesting, and this is unscientific, but we live in an era of social media where Twitter and Facebook and all kinds of reaction means something, and just what exactly it means, I think none of us are quite sure. But I've kind of kept an eye on message boards and things like that to sort of see how people are reacting to certain witnesses. And the witness, Tammy Parker, the attorney, real estate attorney, friend of Andrea Sneiderman, has elicited a strong response, and not all of it positive, on Twitter. Your thoughts on that? She seemed matter of fact. Was it her style? Was it her smoothness? She certainly was playing to the jury and to the judge at various times. That seems to be an element that has rankled some on social media this afternoon.
The comments by the folks
All right,
that
Kelly, we're back on the record.
I'll tell you what, we'll come back to
Bring
that.
the jury, bring
We
the
will
jury.
remember
After reviewing,
that point, and we'll talk about it. Back to Judge Adams.
By the defense, United States versus Billue, B-I-L-L-U-E, and it makes reference to the law is clear that if a witness has denied making a statement or has failed to remember it, although no statement was provided by the previous witness, the making of the statement may be proved by another witness, although it was not propounded to the previous witness. But for the sake of moving this case forward, I'm going to allow Mr. Clegg to ask her that question about what she may or may not have said earlier, what the previous witness may or may not have said to a different individual for the purpose of quote-unquote impeachment, although that witness was not confronted with any statement, at least in this courtroom. What we're going to do is bring in the witness, Mr. Clegg, if you could bring her back in, Ms. Sansbury, and then Deputy Garrett, let's go ahead and bring in the jury at the same time. And Mr. Clegg, she's with you.
Yes, sir.
An exception is noted from the statement. Come on up, Ms. Sansbury. Let's have a seat. Jury will be coming back in momentarily. Thank you for your patience. Yeah, come on up, Lloyd. Yes, sir. Yes, sir. I'm sorry. Come on up, Lloyd. All right, ladies and gentlemen, thank you very much for your patience, and thank you. And it's been brought to my attention, it's warm in here, and we will get the maintenance people to do something about the air conditioning, but for right now, it's just warm. So I understand, and I understand. All right, Ms. Clegg, she's with you.
Okay. Ms. Stansberry, before the recess, I had asked you a question concerning a conversation that you had had with Donna Formato on the 19th of November at Dunwoody Prep. Did you in fact have such a conversation, ma'am?
Yes, I did.
Would you relate to the ladies and gentlemen of the jury at this time what it is that Donna Formato told you at that time, ma'am?
Sure. I decided to go over there before heading over to Andrea's to drop food because I had been involved with the teachers at Dunwoody Prep pretty intimately for the 2 years prior. And so going over there was truly just to give support to the administrators and the teachers. As soon as I arrived at the door, Donna opened and she just started bawling. Was very upset, and she took me back into her little office, which is no more like maybe a 5 by 5 office. And she just started relaying things that happened the day before. She talked about how when it first happened, the shooting happened. The police told her to call Andrea, but not to tell her anything had happened. And so she felt like, I mean, she was still in hysterics with me. And she said, you know, I called Andrea and she kept saying, you know, what's going on? Okay. She then moved on and said, you know, as we were talking about feelings and what was happening, that Miss Katrina and Miss Donna, and Katrina was Sophia and Mason's previous teacher, were in a room with her, and what I remember is that Andrea collapsed in this chair, kind of like a cushiony chair, when she was told that Rusty was shot in that room.
Okay. So the last part of that, the noise, I don't know where on earth that comes from, but could you just repeat that last thing?
Sure.
Because his bell went off. I'm sorry, ma'am.
Sure. What Donna relayed to me was how Andrea collapsed in a chair when she was told in the room that Rusty was shot.
Okay. And she would have been referring, if you understood, back to the events of November the 18th?
The day before, yes.
Okay. This is one day afterwards, correct?
Yes.
Okay. Now, did you have much contact with Mrs. Sneiderman after that particular day?
I had not had any conversations with her that day. We went over to her house, and she was inconsolable, so it was more of just dropping off food, paying our respects, and leaving.
Okay. When you say inconsolable, if you could define that or describe that as best you can.
Sure. There was so much chaos going on in the kitchen and in the living area, kind of the dining room area. She was actually in another room on a sofa, and I literally went from the front door, crossed her, and looked at her, and she just kind of looked up. I don't remember who was sitting next to her, but she had two people next to her, and then I just went into the kitchen with everyone else that was helping out.
Did you have any actual conversation with Mrs. Sneiderman at that time?
No.
Okay. What day would that have been, if you recall, ma'am?
That was exactly right after my my meeting over at Dunwoody Prep.
Okay. So that would have been the 19th as well?
Yes.
Okay. You have become a better friend of Mrs. Sneiderman since that time?
Yes.
not really sure that that is, what has happened since that time is not relevant, so I'm not going to ask you that.
Right.
But during the time that you have known her, have you ever known her to wear a jean jacket?
Never.
Okay. You ever seen her in possession of a jean jacket?
No.
Okay. How many times would you estimate you have seen her since November of 2010?
Multiple times until the arrest.
When
Yeah.
you say multiple, can you quantify it if you can?
More than once a month, that's for sure. Twice a month. I started going over there in the evenings because she really couldn't be by herself, just to help her through this whole process.
At some point, did she begin to go out of the house?
Yes, most of the time at my urging. I like my nights out, and
What's the objection?
Relevance.
Because it's relevant.
Yeah, or again, I'm just going to follow up with when they went out, would she have ever seen the jean jacket?
All right, I'm going to sustain that objection.
Did you ever see the jean jacket or a jean jacket in possession of Andrea Sneiderman at any time?
no.
Thank you, ma'am. Nothing further.
Mr. Jones, your witness.
You and Mrs. Sneiderman are friends?
Yes.
And what kind of friends are y'all?
We are very close friends now.
Very close friends now.
Yes.
Okay, what do you mean by very close friends?
We had a lot of mutual friends and started kind of being in the same circle before the murder. She and I were a little more than acquaintances by the time that happened. But, you know, after the murder and just knowing that it was something that could have happened to any of us, just became more of a support. And through that, just became a lot closer. We have a lot in common, and you know, it's been a long ride since then.
So you're very close friends.
Yes.
How often do you all hang out?
Well, I haven't hung out with her since the arrest in August 2nd, but I was with her at the lake house when that happened.
Okay, I'm not asking you about that.
Okay.
I asked you a specific question.
Sure.
Okay, that's very close. How often do you guys hang out?
Before the arrest, once or twice a month.
Okay, I'm not asking you about an arrest. Okay, if you can just answer my questions, okay?
Okay.
All right. Once or twice a month, and what type of things would y'all do when you hang out?
Most of the time, she really didn't want to leave the house, so we would go over to her house. I do remember a time where we had a reunion at the Mellow Mushroom at Dunwoody Prep with the old teachers, and that was a very difficult time for her to kind of go out in public, but all the kids were there and the teachers. There were times that I would get her out for an hour or two just to sit and have a drink and talk.
So you're her support system, right?
I was.
Okay. And I presume then y'all talked about what was going on in her life, and that's yes or no. Did you or did you not talk about what was going on in her life?
Yes.
All right. And did you talk about this case
Yes.
a lot?
What was going on consumed her, yes.
So did you talk about this case?
Can I clarify this case and the Hemi Newman case?
I'm asking you about this case. Did you talk about this case?
Not as much.
Okay. Now, you spoke with Ms. Sneiderman, right? About this case, right?
Mm-hmm.
Yes?
When she was under investigation, we talked about it.
I'm sorry, maybe you misunderstood me. I need you to answer yes or no.
Okay.
Okay, you spoke with Ms. Sneiderman about this case, yes?
No, if I can explain that answer.
Yes, ma'am, you can always explain your answer.
It wasn't a case when I spoke to her about her being under investigation.
You spoke with Ms. Sneiderman about this investigation, right?
Yes.
Y'all talked about it, right?
Yes.
All right. You've also spoken with Ms. Sneiderman's lawyers, right?
Yes.
About this case, right?
Minimally, yes.
Okay. About your testimony today, right?
Yes.
Okay. And when Ms. Sneiderman, you've referenced her being charged, right? The difference between the investigation and the charge, right?
Mm-hmm.
Is that yes?
Yes.
Okay. And when Ms. Sneiderman was charged, you didn't think it was important to say, hey, somebody to come to the police, to the DA's office, the DA's investigator, and say, hey, I heard somebody say that your husband's been shot at the daycare? I mean, you knew that that was an issue, right?
I had no information about the actual murder of Rusty.
Not what I asked you, ma'am.
Can you clarify your question then?
I'll repeat my question.
Sure.
All right. My question was, yes, when she was charged, not investigated, is that yes?
Yes.
All right. And you found out that she had charges against her. You didn't
Yes.
think it was important to come to the DA's office, to the police, or somebody, all right, and tell them what you've told the defense you heard. You didn't think that was important?
I didn't think I had a role in that.
Well, hold on. You've just testified to this jury that Ms. Sneiderman is your friend.
Yes.
Right? And that you have been Ms. Sneiderman's support system, right?
Yes.
And that you and Ms. Sneiderman, and I'm using your words, are
That's
grown
fine.
close, right?
Sure, yes.
And you didn't think it was important to tell anybody before today that was linked to the state, the police, the DA's office, an investigator, anybody, that you heard somebody say that they heard Ms. Sneiderman, Mr. Sneiderman was shot?
I felt it was the state's or the police responsibility to come to me, considering I testified at our bond hearing.
You felt like it was the state's responsibility to come to you.
If you had questions,
So it wasn't important enough to offer this information if it was going to help your friend?
that was the decision I made, yes.
So is that yes, it wasn't important?
Yes, I made the decision not to go to the police or the state.
Wasn't my question. Yes, it wasn't important.
It was not important.
But she's your friend.
Yes, she is.
And so this happened in 2010, right?
Correct.
So 2010 passed. You didn't say nothing, right? Yes?
Correct.
2011 passed. You didn't say anything, right?
Correct.
2012 passed. And as you stated earlier, you informed the jury she was arrested, right?
Yes.
And you still didn't say anything, right?
Correct.
So now you're showing up for the first time out of the clear blue sky saying that this is what you've heard.
It's what I know.
Okay. Nothing further.
Any redirect?
Yes, Your Honor. Ms. Stansberry, was Andrea Sneiderman arrested in the year 2010?
No.
Was she arrested in the year 2011?
No.
When was she arrested?
She was arrested August 2nd, 2012.
After that date, Mr. James has asked you about whether you came to either the DA's office or the police. Did you trust the police?
No.
Did you trust the DA?
Absolutely not.
Thank you, ma'am.
Any recalls?
Sure, Your Honor. So you just told this jury that there was an investigation before 2012, right, that you knew about?
Yes.
And you knew about that because you were talking to Andrea Sneiderman, right?
Yes.
Right. And you didn't say anything to the DA's office about it during the investigation, right?
No, I did not.
And you just told this jury that after the arrest, you still had the same knowledge, right?
I did.
And you didn't tell the DA's office anything about it then, right?
No.
But you told the defense, right?
Yes.
Okay. One more question, Your Honor. I'm sorry. I apologize. Have you done an interview with a national news network?
Yes.
And what was that national news network?
It was the Crime Siders of CBS, and there were 10 of us that did a group interview.
And you did it in what was it, Friends in Support of Andrea Sneiderman or
Yes.
something like that?
Yes.
And you're a member of that group, right?
Yes, I am.
And how many of y'all is it?
For that interview, there were 10 of us.
And y'all, when I say y'all, I apologize. The
No,
group,
I understand.
Right? Y'all do social media as well, right?
Some people do, yes.
The group does that, right?
Yes.
And the group posts things in defense of Andrea Sneiderman, right?
Yes.
So it's fair to say you're an Andrea Sneiderman advocate, right?
Very much so.
Nothing further.
I have no other questions of this witness, Your Honor. May she be excused?
Lawyers, any objection to Ms. Sansbury being released and excused from her subpoena?
No, Your Honor.
Any objection? All right, you're free to go. Call your next witness. Yes.
Let me get the, hold on, let me confirm.
Oh, sure you can. Sure you can. All right, call your next witness.
Mr. Jack Gay.
All right. You can come on up, sir. Just follow the instructions of Deputy Garrett.
You solemnly swear affirming the testimony you have to give this court should be the truth, the whole truth, and nothing but the truth, so help you God. There's my word in your hand. You may be seated. Please state and spell your name for the record.
Jack Gay, J-A-C-K-G-A-Y.
Mr. Gay, directing your attention back to November 18th of 2010, or November of 2010, where were you living, sir?
4865 Manjay Court,
Okay, if
Dunwoody.
you could come a little closer to, so we can all hear you, okay?
4865 Manjay Court, Dunwoody, Georgia.
Were you in close proximity to the home of Russell and Andrea Sneiderman at that time?
Yes,
Okay. Directing your attention specifically to the morning of the day, at some point did you find out or were you made aware of the fact that Rusty Sneiderman had been shot?
yes,
Okay. On that day, had you observed anything in the morning hours that you subsequently related to the police?
yes.
Okay. First off, what time was it then you made this observation?
Between 8:30 a.m. and 9 a.m.
And how is it that you came about to make this observation, sir?
I was taking the trash out and I had a 9 a.m. business appointment at the Perimeter Mall area.
How far would your house have been from the Perimeter Mall area at that time?
5 minutes.
Okay. What is it that you saw?
I saw a gentleman driving a silver van.
I'm going to object at this point, Your Honor, as to relevance.
Lawyers approach.
Jeff Hutland, you're back with Attorney Jay Strongwater. As the attorneys have approached the bench, we're getting ready to hear from a neighbor of Andrea and Rusty Sneiderman. Here is an email from Paige Guns, and Paige represents a bunch of emails that I've gotten here in the last few minutes. Hey, I really appreciate your commentary throughout all this coverage. However, I don't agree with your take on the testimony of Ms. Parker, Jeff, the attorney. I did not see her as being comfortable and confident on the stand. Rather, I found her to be inappropriate, smiling and laughing in the light of the serious nature of this trial. I was really put off by her. Any thoughts? Sincerely, this is from Paige Guns. And give me your take on this, Jay. How did you interpret her?
I think this is the division between being in the courtroom and seeing all the parties versus a TV camera that's locked in on one particular person and maybe at an inappropriate time. We don't know what was going on. We don't know which of the 12 jurors were paying attention to Ms. Parker versus watching the attorneys, looking at Ms. Sneiderman to see how she was reacting to having a friend on the stand. there's just a lot of the courtroom dynamic that we're not privy to.
Yeah.
And that could give a totally different impression to the ones that are going to decide whether she was a credible witness.
Yeah, here's another one about Tammy Parker. This is from Joy Bailey. It says, Tammy Parker's behavior on the stand, it was a bit over with the smiling and laughing. How professional is it for her, even if she is not a criminal attorney, to turn to the jury, shrug her shoulders, laugh when the defense objected to a question placed to her by the state? And that is a small sampling of the emails and notes that I have received on Twitter that really have lit up after she left the stand. She made a lot of people seriously angry, at least with some of the correspondence that I've received today.
I think at this point in the trial we're left with two very strong witnesses as far as generating emotion or visceral reaction to how they are. You have Ms. Citron, who I don't know what your tweet count was on her when she finished.
Very full that day as well.
Right. And then you have someone who is testifying in direct contradiction to her opinion, which is generating an equal amount of tweets and emails. So it will be interesting to see how the state and the defense address their testimony, and in a postscript to the trial to talk to the 12 jurors to say, how did you read this? Did you realize people on the street had one type of reaction? And oftentimes you'll get a juror saying, I had no idea what you're talking about. What we saw was 180 degrees opposite of your impression.
All right, we are closing in on 5 o'clock, and it has that sort of feel that it's going to go to about 5:30 today, doesn't it?
I think so. I think this judge wants to move the case.
Here's
If
another.
if he has witnesses out in the hallway, he's going to put them up. Remember, the jury didn't come in till 11 o'clock.
Here's another email. Quickly, you guys are doing a great job. I love having Jay Strongwater here today. I'm sorry about the insects that you guys are fighting on camera.
It's nice that I can tweet to myself.
All right, back to the judge.
Oh, you can, and you will. Any questions from the state?
No, sir.
All right. Lawyers, may this witness be released and excused from his subpoena?
No objection from the state, Your Honor.
Yes, sir.
All right. You're free to go, sir. Thank you for coming. Have a good day. Call your next witness.
We would call Stephanie Lockridge, Your Honor.
All right. Come on up, young lady. Follow the instructions of Deputy Garrett.
You solemnly swear affirm that the testimony you shall give this court should be the truth, the whole truth, and nothing but the truth, so help you God. They know your name. You may be seated. Please state and spell your name for the record.
Stephanie Lockridge, STEPHANIE
Lockridge, do you know the defendant in this case, Mrs. Andrea Sneiderman?
Yes,
Do you see her here in this courtroom today?
yes, sir.
Could you point her out for the benefit of the ladies and gentlemen of the jury, please, ma'am, and for the record?
There.
What is she wearing?
A green sweater?
Your Honor, again, may the record reflect that the witness has identified the defendant, Andrea Sneiderman.
The record may so reflect.
Did you know her back in 2010?
Yes.
How is it that you knew Andrea Sneiderman in 2010?
She and Rusty had a home right beside my mother's house at Lake Oconee.
And how long had you known her at that time?
Possibly about 9 years.
Who were you working for at that time?
The Georgia Bureau of Investigation.
How long had you worked for the Georgia Bureau of Investigation?
At that point, 13 years, I guess.
In what capacity did you work for the Georgia Bureau of Investigation?
I was an analyst, a criminal intelligence analyst.
At some point in the month of December of 2010, after the death of Rusty Sneiderman, did you receive a communication or phone call from Mrs. Sneiderman?
Yes.
Could you tell us about that, please?
She called and stated or asked me if there was if GBI was working the case. And I was like, no, we're not working it. And she was just saying that Dunwoody wasn't doing their job. She wanted to see if she heard that GBI was working it, and I said, no, we are not working it.
Did she ask whether or not the GBI could get involved in the investigation of the case?
Yes, and I said that we are an assisting agency, and Dunwoody would have to ask for our assistance.
Absent the request of Dunwoody Police Department to investigate the case, would the Georgia Bureau of Investigation get involved?
Say it again.
If Dunwoody didn't ask, would the GBI get
No.
involved? Okay. And how long was this particular phone conversation, if you recall, Ms. Lockwood?
Maybe 5 minutes.
Okay. Was it sometime prior to the arrest of Hemi Newman?
It was before, yes.
Okay. And sometime after the death of her husband?
Yes.
Good enough. That's all I have.
Who's witness? Mr. James?
Yes, sir. Ma'am, what's your position at the GBI again?
It was a criminal intelligence analyst.
And tell us what that means, what you did.
I would assist the agents in the field. I would run database checks, and if they're out in the field and they're looking for somebody, they would call me and say, I've got this name and a date of birth, can you look and see where I can locate them at?
So the agents would do investigations and you would verify the information that they gave you. Is that correct?
Say it again.
The agents would give you information from their investigation and you would verify the information that they gave you, correct? Through checks and things of that nature?
Yes. Yes, but if they didn't have a lot of information, then I could run Department of Labor and criminal history and stuff like that for them.
Running searches?
Searches, yeah, database searches.
Do you depend on, when you did these searches and you work with the agents, did you all depend on the information that y'all were given? Did y'all depend on that to be reliable?
Mm-hmm.
Yeah, I'm
Yes,
sorry,
sir.
you have to answer
Yes,
yes
sir.
or no.
Yes,
Yes,
sir.
you did. And if it wasn't reliable, could that compromise your investigation?
Mm-hmm. Yes.
Okay. You have no opinion or no information one way or the other whether or not the information in this particular investigation was reliable, correct?
Say it again.
You don't know one way or the other if the information that was involved in this investigation was reliable. In the investigation in this case.
GBI wasn't involved.
So that's no.
No.
Okay, and that's because the GBI was not involved.
Right.
Okay, you were just requested to do something.
No, I didn't do anything.
Well, you were requested to, listen to my question, you were
Okay.
requested to do something. Andrea Sneiderman asked you to see if the GBI could get involved, is that correct?
Yes.
All right.
She asked me if the GBI was involved.
And other than that, you have no further knowledge of anything in this case?
No.
Okay, all right.
Did you have any knowledge of a sketch that had been prepared in the course of this investigation?
Yes.
Okay. What would that knowledge have been?
I just knew that that Marla did the sketch.
Okay. When you say Marla, who is Marla?
Marla Lawson, she was,
I'll object to the foundation of this one because it sounds like it's hearsay, and if it's not, he needs to lay the proper foundation through her that she had firsthand knowledge of
I
the
understand.
sketch.
I'm going to sustain the objection. You want to rephrase your question?
Nah, it's not worth it, Judge. Thank you very much, Mr.
All right.
Judge.
Anything else from the state?
No, sir.
Were you acting in your official capacity or as a friend who took a phone call at your home?
no, I was at work.
Okay, but did you
I was-
run, well, straight there. I know you were at work when you took the call, but were you responding in your official capacity as a representative of the Georgia Bureau of Investigation? Or
No,
as a
she
friend?
just called as a friend.
As a friend?
Yes.
That's what I'm saying. You don't take calls from
No,
victims or victims' families?
no,
You don't initiate investigations?
no, mm-mm.
You don't lead investigations?
No.
You don't assign cases to people?
No, sir.
But the reason she had your number because she was a friend of yours.
Exactly. Yes, sir.
Anything else, lawyers?
No, sir.
No, sir.
Lawyers, are you investigator? May the investigator be released and excused from her subpoena?
Objection from the state, Your Honor.
None whatsoever. yeah.
You're free to go. Have a good day. Drive safely. Call your next witness.
I guess we would call Rabbi Hershey Minkowitz, Your Honor.
All right.
Turn around, raise your right hand. Do you solemnly swear or affirm that the testimony you shall give this court should be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Please lower your hand. Please state and spell your name for the record.
Hirsch, Hirsch, Minkowitz, Minkowicz.
Sir, do you know the defendant in this case, Mrs. Andrea Sneiderman?
Yes.
Do you see her in this courtroom here today?
Yes.
Could you point out for the ladies and gentlemen of the jury and the record where she is and describe what she is wearing?
She's sitting on the table on the left, and she's wearing a green sweater.
Again, Your Honor, may the record reflect that the witness has identified the defendant, Mrs. Andrea Sneiderman.
Yes, sir. The record may so reflect.
When is it that you actually met Andrea Sneiderman?
On November 19th, the day after Rusty was killed.
When you say November 19th, would that have been of the year 2010?
Yes.
Okay. What were the circumstances under which you met or had occasion to meet Mrs. Sneiderman?
Her sister-in-law, her brother's wife, had called me from before, and she called me and asked me if I can come to the house. Originally, she was asking if I can come to the house to help speak to her children.
Object as to hearsay at this point.
Okay. Let me ask you this, sir. Did you know Mrs. Sneiderman's sister-in-law?
Yes.
Okay. Did you have communication with Mrs. Sneiderman's sister-in-law?
Yes.
When would that communication have been, sir?
It was first through email, late...
Just tell us the date.
Late night on November 18th, 2010, and then the following morning, November 19th, 2010.
Did you have occasion then to go to Mrs. Sneiderman's home on November the 19th of 2010?
Yes.
Okay. Was that the first time you had met her?
Yes.
Did you have occasion to develop a friendship with her at that time?
Yes.
Can you describe for the ladies and gentlemen of the jury the condition that you saw Andrea Sneiderman in on November the 19th of 2010, sir?
Okay. When I came to the house for the first time, when I walked in, there was like a little area first, and then you walked into a big area, and off to one side on the right was the kitchen, and she was sitting right at the kitchen table there with her mother, and on the left was a room where we were going to go talk, and I can just remember that her mother literally had to, not carry her, but had to literally escort her because she couldn't even walk across the living room into that room on the side where we were going to talk.
How far is it from one room where you first saw her to the room where you were going to talk?
Probably the width of the jury box, I guess, a little less.
Do you recall how long it actually physically took her to walk that distance, sir?
No.
Okay. Did you have occasion, and again, were you present when she spoke with the police on the evening of November the 19th?
No.
Okay. Now, did you have occasion to meet with her at some other time?
Many, many times. In which time frame?
Okay. Were you attempting to assist her in helping apprehend the killer of her husband?
Oh, yes. After that meeting on the 19th, from that time until January 4th, when the killer was arrested, I had become very, very close with the family, and we had many, many conversations and meetings, and a lot of it was focused on what we could do to keep this story alive in the media, to get the sketch out, to anything that we could be doing, increasing the reward, or all sorts of things like that to help get the guy caught.
Let's go through that point by point, sir.
Okay.
You made reference to a sketch. What sketch are you referring to?
The police released a sketch, I think it was on Friday afternoon on the 19th of the...
I'm going to object at this juncture. It's improper foundation. If this witness has, if the sketch was released to him, if he saw the sketch, then, but...
I'll sustain, Mr. Clegg. You may continue with a different question.
So let me show you what has been marked for purposes of identification and previously admitted into evidence as Defendant's Exhibit number 21. Do you recognize what that is, sir?
Yes.
What is that, sir?
This is the sketch of the killer that was disseminated in the media.
Okay. Have you seen that sketch previously?
Yes.
Was anything done involving you and Mrs. Sneiderman to disseminate, specifically, how did you make an attempt to disseminate that to the media?
Oh, the first thing was on Saturday night, so this is the next day, on November 20th, after late at night, maybe 9, 10 o'clock at night, I came to the house, and at one of the discussions we were having then that there was because there was some...
I'm going to object to hearsay. That's my first objection. My second objection is relevance as to what he did.
Your Honor, I believe that he is doing it with the direct involvement of Mrs. Sneiderman.
I'm going to object. He's testifying.
Hold on for time out, lawyers. But I'm going to hold the objection. I'm going to allow the witness to respond.
Go ahead, sir.
Okay. Andrea asked me to print out a copy of the sketch and take it along with me to the funeral so that in case media showed up at the funeral, because the media was already amassing and hovering over this story, in case the media showed up to the funeral, what we would do is take out the sketch and wave it to the cameras and stuff just to try to make sure that the sketch was being out there and people were seeing it and hopefully somebody would recognize someone.
Was that your intention at the funeral, which was held when?
The funeral was held on Sunday, the next day, and yeah, that was my intention. Yes, I printed it out and I brought it along.
Okay. Was that done with the knowledge and understanding of Mrs. Sneiderman?
Yeah, she asked me to do that, and then I emailed her to tell that I printed out the sketch and that I have it, and that I'm coming to the funeral with it in my pocket.
Okay. Did you show it to anyone who was actually at the funeral other than potential media members, if you recall, sir?
I don't recall, but luckily the media...
Had there been a media presence outside the defendant's home prior to the funeral, if you know?
I was not at the house on Sunday morning. I don't know.
Okay, not on necessarily just Sunday, but at any point when you went over to the house?
Oh, yeah. I mean, the second day after I got there was already a letter from...
The relevance of media presence outside the home, Your Honor?
That would explain why it is that he took the sketch with him and attempted to disseminate it to the media.
Overruled. Go ahead.
Go ahead, sir.
2 days after Rusty was killed, before he was even buried, there was already a letter pasted onto the front door of Andrea's house from the Today Show, asking that they want to interview people and stuff like that, and that kind of thing was going on already in the beginning. So we assumed that they're going to come to the funeral.
Okay. Was there any attempt made to keep the case alive in the media to attempt to apprehend the killer?
Yes, multiple attempts. We met with...
Hold on just for a second before we get into that. Was that done with the knowledge and understanding and at the request of Andrea Sneiderman?
Yes.
Go ahead, sir. Describe the multiple attempts.
Okay. Like about a week after Rusty was killed, a week and a half after, the story was already starting to die down in the news, and Andrea was getting very concerned about that if it's not going to be kept alive, who's going to see the sketch, who's going to call in a tip or something. So we went to have a meeting with the police to try to talk with them about what we can do, maybe increase the reward or do something, because the news, I guess, needed to have a new hook or a new piece of news to keep it back alive again.
Hold up for a second, sir. When you say we went to meet with the police, specifically, who is we?
Okay, Andrea, myself, if I remember correctly, her father and her brother were there too, but for sure she was there and I was there.
Do you recall the approximate date when this meeting, or did you in fact, were you successful in meeting with someone from the Dunwoody Police Department?
Yeah, we met with the assistant to the chief, or the deputy chief. His name is Sides, David Sides. We met with him. It was on November 29th.
Okay. And did you express what you have just related to the ladies and gentlemen of the jury?
Yeah, so we spoke to him and asked him what it is that we could do to keep the story alive. And in fact, he was saying that he doesn't really know what else we could do, and he doesn't even think increasing the reward would make it. But then at the end of the meeting, he suggested to...
Your Honor, as to anything Chief Side says, unless counsel's going to lay the foundation for a prior consistent statement.
I'm at a loss to understand that one, Your Honor. I'll just move it. Oh, okay. Without getting into specific...
I'm going to sustain the objection.
Okay. Without getting specifically into what Mr. Side said, did you get the name of a potential media contact?
Objection, Your Honor. That's, again, hearsay. Did you get the name? That name would have been offered by someone, by an out-of-court declarant, and I presume for the truth of the matter asserted that he in fact got it, which would be classic hearsay.
All right. Let's play response.
No, Your Honor, I do not.
All right. Next question.
Did you contact someone with the media after that meeting?
Yes, I contacted two people. Mark Winnie, he's a reporter for Channel 2, and Christian Boone. He's from the AJC.
Who would have actually contacted these two individuals, sir?
I did.
Okay. And did you do so with was Mrs. Sneiderman aware of the fact that you were contacting these individuals?
Yes, I was updating her every step of the way. Everything I was doing, I was discussing with her.
Did you have her approval when you contacted these individuals?
Yeah, I mean, she was gung-ho, do everything we can to try to get it back up into the media, so absolutely.
What was your purpose in contacting these two individuals, sir?
The deputy chief Sides had told me that this would be a... Oh, sorry.
Just what was your purpose?
The purpose was to try to get the story back in the news again so that it could be on the top of the headlines. The ultimate purpose is that the sketch would be out there so that people would see it and hopefully somebody would call in a tip.
Okay. And do you recall whether any additional media coverage was generated by virtue of your attempts to communicate or your actual communications with these individuals?
Yeah, they actually did a piece. WSB did a piece on December 2nd as a result of that.
Was Mrs. Sneiderman aware of the fact that WSB was going to do that piece?
Yes, she was.
And did she give her approval that they do so?
She gave the approval that I could work with them on the story. I mean, WSB decided if they're doing the story or not, but she gave the approval that I could work with them on the story.
To your knowledge, was that sketch that we have previously made reference to, I believe it is Defense Exhibit number 21, was that featured in any subsequent news story from WSB?
Yeah, it was featured, to best of my recollection, it was featured in that piece on December 2nd.
Okay. You made reference to a reward. Can you tell us about that, sir?
Yeah, so one of the things that we had discussed, Andrea and I and some of the other family members, multiple times was that one of the ways that we might entice someone to call in a tip would be if we increased the reward, and this would also help the media have a new story to run with, that the family increased it. So that's one of the things that was an ongoing conversation, and we did that once for sure, maybe even twice.
Did you have additional contact with the Dunwoody Police Department after November the 29th, sir?
The next time I had a contact with the Dunwoody, well, there were some phone conversations ongoing with Detective Thompson and other things, you know, when we were talking about the reward and stuff. Sorry.
Hearsay conversations with Detective Thompson that he had.
He says he was talking about what he was talking about, sir.
All right. For the purpose of this, I'm going to hold the objection. Go ahead and answer.
Okay, don't go. I mean, I'm not asking you to get into specifics, sir. Did you have contact with representatives of the Dunwoody Police Department after the meeting of November the 29th of 2010?
Yes, I did.
Can you estimate the number of times you would have had communication with representatives of the Dunwoody Police Department after that date, sir?
these attorneys know how far to go with Judge Adams. And the last thing they want to see is to be scolded in front of the jury. They lose credibility if that happens.
Hi, Jeff. Your lawyer friend said in another break, if Andrea is found guilty on one charge, she would be considered guilty of all. Could you explain that?
It was more in the context of sentencing. The judge has this, each count has a maximum sentence. The judge will look at, so if there are 13 counts and she is acquitted of 12 and convicted of 1, she's looking at the same amount of time as if she was convicted of all 13. Sometimes lawyers will look at the jury and say, acquit us of everything or nothing, but don't give us a compromise verdict.
This is from Jill Elliott. I've covered this case 98% of its duration. I may have missed a crucial point. Was there testimony in the case regarding the fact that Andrea Sneiderman telling police of her suspicions about Hemi Newman on January 4th, that came immediately after her receipt of her $2 million life insurance benefit checks? And has there been any on-air discussion that any insurance company may have delayed the payout of life insurance benefits if a significant relationship between the arrested person and the widow of that person were shown?
I have followed less than 98% of the trial, so I cannot comment on what has been said in the courtroom. Insurance policies do have a reserve clause that if the beneficiary of the policy has participated in or caused the death of the insured, that they could hold back the funds. In this case, they paid it out before the DeKalb County authorities or Dunwoody authorities decided that Andrea was a target of these events.
There's a couple of other ones. Let's see, we are back. I see Tom Clegg right now in front of Judge Adams, so let's listen in.
And was able to, from a close vantage point, observe that the vehicle was occupied by one person, and that was an individual who would have been wearing a hooded sweatshirt and appeared to be of either Hispanic or Middle Eastern descent. That would have been essentially the extent of his testimony. He would not have thought terribly much about that at the time, subsequently became aware of the fact that Rusty Sneiderman had been shot and that a silver van had been seen leaving the scene, then subsequently contacted the police and notified them of that fact. We would have been seeking to elicit that testimony to show, one, to support the inference, to support the statement that Andrea Sneiderman had made to the police that in fact Hemi Newman was in fact stalking her, and also to provide an inference that it was Hemi Newman on the side of the house on November the 10th, 8 days earlier, who had been present at that time. The court will recall there was testimony that a Hispanic man was found sitting by the side of the house. As the court will also recall, during the course of the original statement that Mrs. Sneiderman made to the police, she emphasized to the police her belief that there was a connection between that particular incident and the death of her husband, and tried to discourage the police from investigating business contacts or folks who had done business with her husband. We offered that to support the inference that that in fact was Hemi Newman, and also to show that she was the one who was not leading the police astray. As a practical matter, it was the police who were leading themselves astray in the course of their investigation. I would also note for the record that Investigator Potter had filed prepared a sworn affidavit which was filed in the Superior Court of Fulton County, which contained a statement that Hemi Newman was the person on the side of the house on November 10th of 2010.
All right, Mr. James, who's witness?
Your Honor, the problem, and Mr. Clegg said a lot, but the problem, I can make it very short, is that it doesn't support the inference that it was Hemi Newman on the side of the house. The only testimony in this trial is that somebody on the side of the house had a beard, they looked like a Hispanic male. There's nothing else that's come out that said Hemi Newman was even in America on that day, more or less at the defendant's house on the side of the house. Second of all, the defendant didn't see anything, her husband saw it. So I don't really understand how the fact that somebody had a van and looked Hispanic and had a beard, whether that beard was real or fake, supports an inference that it was in fact Hemi Newman when there's no evidence presented in this trial that, you know, Hemi Newman was that person. So it's not relevant.
All right. Anything else for the record?
The only thing I would note for the record, Your Honor, is just so we're clear. I don't believe Mr. Gay would have said the individual had a beard on at the time, and I don't believe the evidence would have been that Mr. Newman had a real beard. So I don't know if that's terribly germane to anything one way or the other. I just wanted to clear that up. So no, I have nothing else on that subject.
All right, Mr. James, anything else for the record?
Yes, Your Honor. The only other thing that I would add in light of counsel admission, in light of counsel's admission on the record, it makes it even more irrelevant because he's saying I don't believe that he had a beard. At least in the sketches that we have, the individual has a beard. If Mr. Gay saw someone and they didn't have a beard, it doesn't even support an inference.
Anything else for the record from the defense?
Nothing else for the record, Your Honor. Excuse me, nothing else for the record. Yes, sir.
Anything else for the record for the state?
No, sir.
All right. Let me, well, Kelly, we're off the record. The lawyers, this approach momentarily, this is on arranging some things.
Off the record again, says Judge Adams, but we are not done yet. Coming up on 5:30 right now, joined by Jay Strongwater. Jay, what's going on right now?
Right now they're debating, or the defense is asking the judge to reconsider the limitation of the neighbor's testimony. Mr. Clegg has made something called a proffer. He's made representations of what his questions and what the testimony would have been if the judge would have allowed it. So there's a detailed factual statement. Had you allowed me to ask this witness questions, he would have testified that he saw a fellow on the side yard, that it was called in and the DeKalb County or Dunwoody authorities didn't do their job. That's the inference they want to say. The judge has already ruled that it doesn't come in, and so once again what he's saying is, appellate court, if there's a conviction, we think the conviction was wrongly entered because we were not allowed to introduce this type of testimony for the jury to hear.
I got a text from somebody who works in the law business who wanted to know if you've ever seen a judge who has a kill button on the audio the way Judge Adams does on this, and essentially is playing judge and also editor, in terms of deciding what goes in and what goes out.
I have not, and it's interesting that they're having a sidebar. When the sidebars are generally held because the judge does not want to excuse the jury and he wants to talk to the attorneys about a legal issue. The jury's not in the courtroom, and it's interesting that the judge wants people at the sidebar to have this discussion. There's really no necessity other than to keep the public unaware of the exchanges that are going on.
Headline of this day remains the possibility, the specter, that Andrea Sneiderman may be testifying in this trial. Would we see her tomorrow, or would it be on Thursday if that decision is ultimately made today?
It would seem that the rabbi's testimony is a logical end to the witnesses, which would drive the question tomorrow where the judge will ask Andrea Sneiderman, do you wish to testify? If she says, no, I don't, tomorrow's trial will come to an abrupt halt. There may be something called rebuttal testimony, but the jury will be excused. The parties will talk about how the jury should be instructed, and they would probably start fresh Thursday morning so they could have a unified closing argument, jury instructions, and the jury gets to start to deliberate.
So then you think tomorrow morning at 9 a.m., though, we'll have a much better sense of how this is going to play out?
Yes. Now, the witness on the stand now is not done. We have no idea how much longer he has on direct. The state, of course, has a chance to cross-examine. So you figure about 10:30 or so, if he's the last witness, then there'll be this dramatic moment of, Ms. Sneiderman, do you wish to testify? Have you been advised by your attorneys? What is your free choice as to what to do?
Andrea Sneiderman has been more active today in terms of the pen and in terms of papers, and if you didn't know better, would assume that maybe she was another attorney simply sitting at the desk. How important is her counsel at this point?
They're important. Again, this is a team effort. Ms. Sneiderman knows the witnesses that are testifying. She's had private conversations with these witnesses. The attorneys have interviewed these witnesses, and she may feel that there's certain salient points that they're not bringing out, and she wants to remind them to do it. Also, tonight they're going to caucus in order to prepare for closing argument, and she's making notes about what she thinks has made an impression on the jury.
There's one of our viewers who says, great coverage today. enjoying Jay Strongwater a lot. In fact, the practical, direct approach to legal issues as opposed to providing the regurgitation of the law is something that has made this experience over the last couple of hours enjoyable. So tip of the cap to you from one of our viewers.
Thank you, and I'm going to thank all my friends that have been sending messages to Jeff complimenting me, and dinner will be a place to be determined.
There also has been, the rabbi has gotten a lot of attention too on Twitter and social media as well about his role in all of this. Is it unusual to have someone such as he on the stand?
Yes. First of all, there's a privilege. In fact, the statute says that clergy are incompetent witnesses. So it would require the rabbi to give up his privilege. It would also require Ms. Sneiderman to give up her right to keep her confidential communications away from the jury.
Is that to appeal to the spiritual sensibilities, if there are such things among the jurors?
Yes. He's a man that hopefully the jury will look at and say he has credibility. The weight of his testimony supersedes the weight of other people whose testimony has been contradicted or in dispute.
All right, I'm looking at a live feed. We are in recess for the day. Derek is our director. All right, 9 a.m. tomorrow. So when we see the color bars, Jay, we generally know that all good things must come to an end, and today's session has certainly come to an end.
It's been a pleasure.
It has been a pleasure. We really appreciate you sitting here in these hot times under these tents here outside the DeKalb County Courthouse for the last 10 hours, talking about matters as it relates to the judicial and helping all of us understand it a little bit better. I mean, we have so many questions here for you that I don't know where to begin. Maybe we'll begin tomorrow. We have plenty of time to ask more questions. You're not going to be with us tomorrow, though.
No, but I look forward to hearing you and the attorneys that are going to be helping you
the
for the
attorney
rest of the
du
trial.
jour. We were very lucky with the luck of the draw today. Your observations have just been spot on, and we really appreciate it. So give me some closing thoughts. Not exactly a closing argument from you, but give us something similar, if you would.
I think the jury is still out. I don't think there's been enough evidence to say that the case is over for either side. I think it will be very interesting to see the closing arguments where they'll have to weave the law, the testimony, and the videos all together. And I look forward to seeing very competent attorneys put forth their best efforts.
Where does the advantage lie right now?
I can't tell.
Yeah.
It's again, it's a feel that you get in the courtroom, and we haven't been in the courtroom to get a sense
And
of how
by
they're
feel,
doing
you mean
that.
looking into the eyes and the expressions of the jury.
Correct. Body language is, I think, plays a role.
So really the top stories today would be the fact that Andrea Sneiderman has hinted to Judge Adams that she may testify. The other one is from her friend Tammy Parker, who testified today, who had decidedly mixed reviews among many of our viewers today. She was sort of the opposite of Shana Citron, only she is not described as a former friend now of Andrea Snyder, but a current friend. And she went to bat for Andrea that there really wasn't any issues in her marriage, at least that were overt from her experience in dealing with a personal relationship.
Correct. I would take issue with the first. I think it was proper for the defense team to tell the judge it was premature to ask Ms. Sneiderman for a commitment.
Okay. All right, that's it for us, and thank you very much for being a part of 11 Alive's continuing coverage of the trial of Andrea Sneiderman. 11 Alive News is coming up in about 25 minutes, and we will have a wrap-up. Jay Watson will join us. She has been inside the courtroom along with Julie Wolf, so we will have some of their observations coming up at 6. At 7 o'clock, I will be back here with Marcia Shine, who is a fine attorney that you have seen on our airwaves over the course of the last couple of weeks. She will be with Judge Hatchett and Brenda Wood on the broadcast that's coming up at 7. Then we have the rundown at 10 o'clock on my ATL TV, and 11 o'clock, 11 Alive with a compendium of all that has transpired here inside the courtroom and outside in Atlanta Metro. So for our attorney, Jay Strongwater, you know, I almost booted your name here as we closed it out after all of these hours. It is a long day as we have monitored the trial and fought some of the insects out here. Again, we appreciate it. And thank you for watching. We will see you tomorrow.